Constitution Day proper is September 17th, yesterday, which marks the day, 1787, that the members of the Constitutional Convention in Philadelphia concluded their drafting of the Constitution and signed their new document. Of course, for those involved in the new Constitutional Studies minor, every day is Constitution Day. If you're interested in the minor, please come talk to me, or you can find out more information on our website, constudies.nd.edu. And one of the reasons when we proposed the Constitution Studies minor, the undergraduate minor, was to foster connections between the law school and the College of Arts and Letters. And I'm very pleased to see many representatives from both colleges here today. A number of different groups provided support for today's lecture. I'd like to thank a few of them. AJ Polita and the Law School's program in Constitutional Structure. Thank you, AJ. And also the Notre Dame Office of Research and the Provost's office. We owe them special thanks because they bought you lunch. Let me also thank Rick Burnett. Rick, the Associate Dean of Law School, really was sort of the glue that helped me put this event together, helped me put together. Rick's a good friend and a great scholar, and he just published a really fantastic article on last year's Supreme Court term, and we printed some copies of them. I think they're at the entrance, so please grab a copy if you haven't already. Grab a copy already. It's a very nice overview of last year's term. I recommend that article to you. Okay, now to our main event. It's my distinct pleasure to introduce Dr. Barry Cushman to you. Dr. Cushman is the Notre Dame John P. Murphy Foundation Professor of Law. He joined the Faculty of Law this year, and I'm sure I speak for all of those who teach constitutional law, constitution-related matters here at the university. We are absolutely thrilled that you chose to come to Notre Dame. He is an award-winning teacher. He's also a distinguished scholar. His book, Rethinking the New Deal Court, The Structure of a Constitutional Revolution, published here from Oxford University Press, was awarded the American Historical Association's 1998 Littleton Griswold Prize in American Law Society. Dr. Cushman is widely recognized by those who study the courts of the Constitution. He's really one of the leading legal historians of his generation. And it really is a credit to law school and those in arts and letters that helped bring him to Notre Dame. His address today is titled Obamacare, the Supreme Court, and the Lost Generation of Child Labor Reform. Please join me in welcoming Dr. Barry Cushman.
Thank you, Phil, for that very generous introduction. Thank you all for coming out today, especially given the inclement conditions outside. My talk was originally going to be titled The Healthcare Decision and the Lost Generation of Child Labor Reform, but Philip thought we needed to jazz it up to get you all out here, especially on a rainy day, so that accounts for the change in title. At the end of last term, the Supreme Court of the United States decided the case of National Federation of Independent Business versus Sebelius, which concerned the constitutionality of provisions of the Patient Protection and Affordable Care Act, sometimes referred to as the ACA or Obamacare. The particular provision of the act that was challenged was the so-called individual mandate, which will require persons without health insurance to acquire minimum essential coverage by 2014, or else make a shared responsibility payment to the Internal Revenue Service. In the briefing and oral argument and press coverage of the case, most of the attention was focused on the question of whether the individual mandate could be justified as an exercise of Congress's commerce power. That is, its power to regulate commerce among the several states. Chief Justice Roberts and four of his colleagues held that the individual mandate was not a legitimate exercise of the commerce power. However, the Chief Justice and four different justices made a majority to uphold the shared responsibility payment as an exercise of Congress's taxing power. In determining whether the shared responsibility payment constitutes a legitimate exercise of the taxing power, both Chief Justice Roberts and the dissenting justices agreed that the central question was whether the act imposed a true tax or instead imposed a penalty. A penalty for failure to comply with a congressional directive. The distinction between true taxes and regulatory penalties may seem obscure to many of us because until recently it was little more than a remote artifact of the constitutional history of the early 20th century. For better or worse, that is the subject that I spend most of my waking hours thinking about. So I hope you will indulge me while I try to explain it to you. In the late 19th century and for the first 4 decades of the 20th, the justices of the Supreme Court construed Congress's powers into the commerce power much more narrowly than they would subsequently. For example, the court held in several cases that the Commerce Clause did not authorize Congress to regulate activities of production, such as manufacture, or agriculture, or mining. These activities, like purely intrastate business transactions that did not involve the movement of a product across state lines, could be regulated only by state and local governments. Under these circumstances, Congress frequently sought to achieve regulatory objectives it could not attain through its commerce power by imposing excise taxes that were designed to discourage disfavored activities. Occasionally, these exactions were challenged before the Supreme Court. And the justices permitted this indirect fiscal regulation of various local activities, such as the intrastate distribution of narcotics and the intrastate sale of machine guns and sawed-off shotguns, even though the taxes on these activities were intended by Congress to discourage them. The leading example involved an excise tax on oleomargarine, a butter substitute greatly feared by dairy farmers at the turn of the 20th century. In 1902, Congress imposed a tax of 1/4 cent on the production of uncolored oleomargarine, but a tax of 10 cents per pound, that is 40 times as much, on oleomargarine colored to resemble butter. The tax was admittedly designed to discourage the production of oleomargarine colored so that it would compete with butter, and such a regulation could not have been sustained under the commerce power at that time. Nevertheless, in 1904, the court upheld the measure as an exercise of the taxing power. It would not be long, however, before the justices would become concerned about Congress's increasingly aggressive use of the taxing power to regulate matters it could not reach under the commerce power. That issue would come to a head in a 1922 case involving the regulation of the employment of child labor. In 1916, Congress had passed the Keating-Owen Child Labor Act. That act prohibited the interstate shipment of articles produced by firms that employed children under the age of 16 in mines or quarries, or employed children under the age of 14 in any mill, cannery, workshop, factory, or manufacturing sector. It similarly prohibited interstate shipment of goods made by firms that employed children between the ages of 16 and 14 for more than 8 hours per day, or for more than 6 days in a week, or before the hours of 6 a.m. or after the hour of 7 p.m. In 1918, the Supreme Court invalidated that act in the case of Hammer against Dagenhart, holding that the statute was not a legitimate exercise of the commerce power. Congress responded by adding a provision to the Revenue Act of 1919, imposing a 10% excise on the net profits of any firm employing children in violation of any of the standards that had been established by the Keating-Owen Act. That exaction was successfully challenged in the case of Bailey against Drexel Furniture Company, more commonly known as the Child Labor Tax case. In his opinion for the majority, Chief Justice William Howard Taft insisted that the exaction was not a true tax, but was instead a regulatory penalty. The imposition here was not merely a simple excise on a commodity or good, such as liquor or tobacco or oleomargarine or cocaine. It was instead, Taft said, a heavy exaction for a departure from the detailed and specified course of conduct in business. The statute contained elaborate specifications on the face of the act, indicating the purpose to regulate a matter completely left to the state governments under the federal constitution, and accompanied by a heavy exaction to promote the efficacy of that regulation. Taft recognized that excise taxes often had a purpose and effect to influence behavior, and that alone, he noted, did not cause an excise to lose its character as a tax. But there came a time, he insisted, in the extension of the penalizing features of the so-called tax when it loses its character as such and becomes a mere penalty with the characteristics of regulation and punishment. The child labor tax, the court concluded, presented such a case. The Chief Justice did not deny that the reduction of child labor was a worthy policy objective. Nevertheless, he maintained that it was the high duty and function of the court to decline to recognize or enforce federal statutes dealing with subjects not entrusted to Congress, even where it required the justices to refuse to give effect to legislation designed to promote the highest good. The good sought in unconstitutional legislation, tapped Warren, is an insidious feature because it leads citizens and legislators of good purpose to promote it without thought of the harm which will come from breaking down recognized standards. Grant the validity of this law, the Chief Justice reasoned, and all that Congress would need to do hereafter in seeking to take over to its control any one of the great number of subjects of public interest reserved to the states by the Constitution would be to enact a detailed measure of complete regulation of the subject and enforce it by a so-called tax upon departures from it. To give such magic to the word tax would be to break down all constitutional limitation of the powers of Congress and completely wipe out the sovereignty of the states. It would constitute, Taft concluded, a breach in the ark of our covenant under which the country had been able to endure and prosper for nearly a century and a half. Unlike Hammer against Dagenhart, which was decided by a vote of 5-4, the decision in the child labor tax was supported by 8 of the 9 justices. 3 of the justices who had dissented in Hammer, Justices Joseph McKenna, Oliver Wendell Holmes, and Louis Brandeis, each of them joined Taft's opinion. That same day, the court unanimously followed the child labor tax case in striking down an excise tax that was designed to induce commodities exchanges to submit to extensive federal regulation of futures transactions. And a little over a decade later, the court would again follow suit in invalidating an excise tax, penalizing employers who did not submit to federal regulation of wages, prices, and labor relations in the coal industry. Decisions in the early 1950s would uphold simple excises imposed on the sale of marijuana in the business of taking bets, but these later cases purported to be acting consistently with the child labor tax case, and certainly none of them claimed to overrule that decision. Commentators continue to regard the child labor tax case as good law, and the Supreme Court had treated it as a governing precedent at least as recently as 1994. Now, after the court's 1942 decision in Wickard against Filbert, the Commerce Clause was commonly thought to enable Congress to reach almost any activity, no matter how local it might have been considered by an earlier generation of justices. With such a broad commerce power, Congress no longer needed to resort to the taxing power to achieve its regulatory objectives, and until last term, the most recent major taxing power case had been decided in 1953. Beginning with the Lopez decision in 1995, however, the court has begun in some cases to construe the Commerce Clause a little more narrowly than it did for most of the 20th century. These developments in Commerce Clause jurisprudence raise the question of whether Congress's reach under its taxing power would again exceed its grasp under the Commerce Clause. If the court were to decide that Obamacare's individual mandate could not be upheld as an exercise of the commerce power, the issue of the scope of the taxing power might emerge as the central question in the case. Though they divided on the commerce power issue, all of the lower federal courts that addressed the issue concluded that the Act's shared responsibility payment was a regulatory penalty rather than a tax. Several features of the Act's language and legislative history led the district and circuit courts to coalesce around this view. I'll mention just a few. First, Congress on the face of the statute expressly characterized the exaction as a penalty rather than as a tax. That was especially significant in view of the fact that earlier versions of the bill had expressly characterized the payment as a tax, which indicated that the choice ultimately to call it a penalty was conscious and deliberate. Second, the Act did not purport on its face to be exercising the taxing power. Instead, the legislative findings made it clear that Congress had relied exclusively on the power conferred by the Commerce Clause. And finally, the lower courts agreed that the shared responsibility payment was not intended or designed to raise revenue. The Act didn't mention any revenue-raising purpose or effect that would be served by the exaction, and the fact that it was projected eventually to produce some $4 billion per year in revenue, did not make the shared responsibility payment a tax rather than a penalty, lower courts concluded, because the Supreme Court had recognized in 1994 that in our world of less than perfect compliance, penalties generate revenue just as surely as taxes do. The Act's purpose and effect, thus, lower courts concluded, were to induce people to purchase and maintain health insurance. To the extent that the Act raised revenue, one judge observed, its proponents would regard it as unsuccessful. At the Supreme Court, Chief Justice Roberts and the dissenting justices agreed that the child labor tax case remained good law, but they nevertheless reached divergent conclusions on the question of whether the shared responsibility payment imposed a tax rather than a penalty. The dissenting justices followed the lead of lower federal courts in concluding that the statute was properly construed as imposing a penalty. They argued that the Act, which referred to the payment as a penalty 18 times, offered, in their words, a mountain of evidence that the payment was what the statute calls it, a penalty. Chief Justice Roberts, by contrast, offered a generous saving construction of the statute as a tax, applying the maxim that every reasonable construction must be resorted to in order to save the statute from unconstitutionality. Granting the Act a full measure of deference to federal statutes, Chief Justice Roberts concluded the mandate could be interpreted as imposing a tax. Now, the resolution of this issue of statutory construction did not conclude the matter, of course, because in the child labor tax case, the court had held that an exaction was a penalty even where the statute characterized it as a tax. The second issue for Chief Justice Roberts, therefore, was whether, assuming that the statute's language could be construed to impose a tax, the statute imposed a tax rather than a penalty within the meaning of Article 1 of the Constitution. This required Chief Justice Roberts to grapple with the precedents. He did not purport to reject the authority of the child labor tax case. Instead, he reviewed the features of the child labor tax that had prompted Chief Justice Taft and his colleagues to conclude that the measure imposed a regulatory penalty, and then offered several distinctions between the ACA and the earlier exaction. Let me consider each of those distinctions in turn. First, the burden of the exaction. Chief Justice Roberts argued that the child labor tax imposed an exceedingly heavy burden, 10% of the company's net income, on those who employed children, no matter how small their infraction. By contrast, he noted, for most Americans, the ACA shared responsibility payment would be far less than the price of insurance, and it could never be more. Thus, the Chief Justice wrote, it may often be a reasonable financial decision to make the payment rather than purchase insurance, unlike the prohibitory financial punishment imposed by the child labor tax. The problem with the child labor tax, Chief Justice Roberts suggested, was not that it sought to influence conduct. Many legitimate taxes had that purpose and that effect. The problem with the child labor tax was that the levy it imposed in order to do so was prohibitory. Chief Justice Taft, in his opinion, did describe the child labor tax as prohibitory, but that seems to have been putting it a little too strongly. There can be no doubt that the tax reduced the employment of child labor, but it clearly did not prevent such labor. The 1920 census, taken the year after the tax went into effect, still showed nearly 17,000 underage children employed in mining and manufacturing in the United States. Though the data are not sufficiently granular to support robust conclusions about the manufacturing sector, they nevertheless reveal a significant decline in the employment of children in the years since the 1910 census. However, as a number of historians of child labor have pointed out, it is not clear to what extent these reductions in the employment of children should be attributed to the effect of the tax and how much to other factors, such as significant improvements between 1910 and 1920 in the standards imposed by state child labor laws and state school attendance laws, advances in mechanization requiring the operation of skilled older workers, the growth of organized labor which opposed competition from cheap child labor, and changes in parental attitudes toward child labor. What is clear, however, is that the child labor tax did not eliminate the forms of labor that triggered its application. As the 1922 report of the chief of the Children's Bureau put it, the returns from the 1920 census taken at the beginning of a period of industrial depression and with the federal child labor tax discouraging their employment, show fewer children under 14 and 16 gainfully employed than did the census of 1910, but the decline is much less than it should be. As the New York World editorialized when the tax was being considered by Congress, we can see no objection except that the proposed federal tax is too small. 10% of the value of the products of enslaved childhood is not enough to emancipate the youth of the South, or to curb the greed of its employers, or to correct the depraved public sentiment against which the levy is aimed. The fact that the tax was not in a strong sense prohibitory is reflected in the fact that it actually generated revenue. In fact, the tax raised more annual revenue than the combined totals from the National Firearms Tax of 1934 and the Marijuana Tax of 1937, both of which the court upheld unanimously. The production of revenue may be a necessary condition for it is actually to be characterized as a tax, but it clearly is not a sufficient condition. For the regulatory penalty imposed by the child labor tax actually raised revenue. Indeed, there is a feature of the child labor tax that may in some instances have made it even less coercive of behavior than were some of the taxes the court has upheld. For under the child labor tax, it was possible to engage in the activity that was subject to taxation and nevertheless legally escape payment of the tax. This is because the child labor tax imposed an excise on the net profits of a firm employing child labor. In computing the net profits of the business, the statute allowed deductions for a variety of expenses. The availability of these deductions provided opportunities for strategic tax avoidance. An entity could, for example, elect to incur deductible costs in years in which child labor was employed and in which significant profits were made or anticipated. In addition, the deductibility of reasonable payments of salary made it possible for closely held businesses to compensate owners and family members by placing them on the payroll and thereby reducing the firm's exposure to the child labor tax. The annual reports of the Commissioner for Internal Revenue suggest that at least some companies employing child labor engaged in such strategic tax avoidance. Those reports reveal that there were a number of companies employing children who managed to pay very little or no tax, meaning that they had little to no net income on which to impose the excise. Either through lack of financial success or as a result of attentive planning, a number of firms employing child labor appear to have reduced their tax liability to modest or nominal sums, or to have eliminated such liability altogether. For a number of firms, then, it may have been, as Chief Justice Roberts says of the ACA's shared responsibility case, a reasonable financial decision to employ child labor and pay whatever tax, if any, might result. Moreover, child labor reformers apparently did not believe that the tax could be salvaged by lowering the rate to make it less prohibitory, nor by tailoring it to be more closely proportioned to the extent of the offense. As Chief Justice Roberts pointed out, Chief Justice Taft had observed that an enterprise employing children was required to pay 1/10 of its entire net income for a whole year, whether it employed 500 children for a year or only one child for 1 day. The idea of imposing a lower or more closely tailored rate had in fact occurred to child labor reformers. In the immediate wake of the court's decision in Hammer against Dagenhart, at least 2 members of Congress had proposed such legislation. One suggested that Congress tax all companies employing underage children $2 per day for each child so employed. Another would have imposed an excise tax of 5 rather than 10% on the company's net profits. But neither of those proposals was revived in the wake of the child labor tax decision. Now they were no longer regarded as constitutionally viable options. Chief Justice Roberts also offered 2 other distinctions between the ACA and the child labor tax. First, he observed, as had Chief Justice Taft, that the child labor tax contained a scienter requirement imposing the exaction only on those who knowingly employed underage laborers. Such scienter requirements, he explained, are typical of punitive statutes because Congress often wishes to punish only those who intentionally break the law. By contrast, the Chief Justice noted, the individual mandate contains no scienter requirement. Second, and again following Taft, Chief Justice Roberts observed that the child labor tax was enforced in part by the Department of Labor, an agency responsible for punishing violation of labor laws, not collecting revenue. The ACA shared responsibility payment, by contrast, was collected solely by the IRS through the means of taxation. Now, it is true that those features distinguish the shared responsibility payment from the excise imposed by the child labor tax. But child labor reformers in the 1920s did not regard these distinctions as constitutionally significant. They did not believe that the child labor tax could be revised and made constitutional by removing the scienter requirement, or by moving enforcement entirely into the Department of the Treasury. Instead, these reformers read the court's decision to imply that the problems with the statute ran much deeper. They believed that the justices had taken the possibility of national regulation of child labor through taxation off the table. They thought that the court's two decisions established that Congress had no power to regulate child labor in the states, and that the only way that it might acquire that power was through an amendment to the Constitution explicitly conferring such power. The National Child Labor Committee thought so, President Warren Harding thought so, future Supreme Court Justice Felix Frankfurter thought so, and eminent legal scholars such as Harvard Law School Dean Roscoe Pound thought so. This opinion was perhaps expressed most colorfully by the redoubtable Florence Kelley in her testimony before the House Judiciary Committee. Kelley testified that she was convinced by the court's two child labor decisions that it would be childish and fatuous to attempt once more to regulate child labor by the method of federal legislation. Instead, Kelley insisted that only a constitutional amendment could do the job. Republican Ira Percy of Maine, seeking to clarify Kelley's position, asked, "Would you rather the committee should pass another law without the constitutional amendment and put it up to the Supreme Court, or would you rather we should pass or submit an amendment to the Constitution?" To this, the exasperated Kelley responded, "No, sir. I would be glad to say that in recent years we have come to believe that the moron is a person who is incapable of learning by experience. We have tried twice, with the advice of the wisest lawyers whom we could summon to our aid, to frame laws that the Supreme Court would uphold, and having failed twice, I think we would enlist ourselves among the morons if we spent another 40 years experimenting with the field of federal legislation." This view was widely shared by members of both parties in both houses of Congress, and they quickly framed and passed such an amendment, sending it to the states for ratification in 1924. In short, contemporary observers deeply engaged with the issue of federal child labor reform did not believe that the child labor tax could be revised so as to pass constitutional muster by eliminating the distinguishing features identified by Chief Justice Roberts. Instead, they believed that any such efforts to frame and enact a revised taxing measure that could run the judicial gauntlet would be futile, and instead turned their attention to an effort to amend the Constitution to permit Congress to enact federal child labor legislation. A crucial point of agreement between Chief Justice Roberts and the dissenting justices can be found in the test they employed in discerning whether the exaction imposed by the ACA was a tax or a penalty. In distinguishing penalties from taxes, the Chief Justice wrote, the court has explained that a penalty is punishment for an unlawful act or omission, an exaction imposed by statute as punishment for an unlawful act. Thus, for both Chief Justice Roberts and the dissenters, the issue was whether the ACA made the failure to maintain qualifying health insurance unlawful. The dissenting justices thought that the act unquestionably commanded that every applicable individual acquire minimum health insurance coverage and imposed a penalty for failure to do so. Chief Justice Roberts, by contrast, concluded that under the ACA, it was perfectly legal not to secure such insurance so long as one paid the tax imposed for failing to do so. This interpretive dispute was, in my view, an unnecessary detour because it proceeded from a definition of a penalty taken from a 1931 case seeking to determine whether an exaction imposed additional punishment for a crime in violation of the Double Jeopardy Clause. That definition was never controlling in the child labor tax case and its progeny, which held that punitive taxes were penalties even though the conduct triggering the tax was not unlawful. Thus, even if Chief Justice Roberts' interpretation of the tax is the correct one, the statute is the correct one, the feature of the ACA in question does not distinguish it from the child labor tax. In his brief before the court in the child labor tax case, Solicitor General James Beck argued unsuccessfully that an exaction was a penalty where the statute prohibits the doing of an act and as a sanction imposes a pecuniary punishment for violating the act. But it was a tax where it merely imposed an excise on the privilege of performing a legal act. Beck pointed out that child labor tax did not pretend to prohibit the employment of child labor. If a manufacturer desires to employ child labor, he wrote, he is free to do so. But if he does so, he must pay an excise tax for the privilege. The statute left the manufacturer free to exercise what Beck characterized as his undoubted right to employ child labor. It merely required a manufacturer who employs child labor to pay a tax not imposed upon one who does not employ child labor. Indeed, in his opinion for the court, Chief Justice Taft recognized that the child labor tax did not, in his words, expressly declare that the employment within the mentioned ages is illegal. As the dissenting justices in the Obamacare case suggested, the ACA might at least plausibly be interpreted as imposing a legal duty to acquire and maintain minimum essential coverage. By contrast, as Chief Justice Taft recognized, there was no plausible argument in the child labor tax case that entities employing child labor were thereby violating federal law. Nevertheless, the court there in the child labor tax case concluded that the putative tax was in fact a regulatory penalty. This pattern was repeated in the court's decisions invalidating as regulatory penalties taxes designed to induce submission to regulation of commodities futures contracts in the coal industry. Neither of those statutes either made failure to abide by the regulations in question unlawful. They merely made a payment to the government the price of refusing to submit. The child labor tax case and its progeny make it clear that it is not necessary for an exaction to be deemed a penalty that the conduct taxed be unlawful. To sum up then, the child labor tax did not make the employment of child labor unlawful. It did raise revenue. It did not, in fact, prevent the employment of child labor, and its proponents did not think that it could be salvaged by lowering the rate, by a more narrow tailoring of the tax, by removing the scienter requirement, or by moving enforcement entirely into the Department of the Treasury. What was it then that made the child labor tax an unconstitutional penalty? And why did contemporary child labor reformers regard the prospect of a revised child labor tax that would pass constitutional muster as a delusion? For illumination of this question, let us turn to the reaction of one of the period's most astute contemporary commentators on constitutional law. Thomas Reed Powell, then a professor at Columbia Law School and later a professor at Harvard, was one among several commentators who believed that the court's decision in Hammer against Dagenhart was wrong, but that the child labor tax case had been correctly decided. In 1922, Professor Powell published 2 articles analyzing the child labor tax case. Like other contemporaries, he did not think that the elimination of the Act's scienter requirement or placing enforcement entirely in the Treasury Department or more narrow tailoring of the exaction would have saved the statute. Nor did he believe that it was necessary that the tax be completely prohibitive of the targeted behavior in order to be deemed a penalty, for he recognized that the child labor tax had not completely eliminated child labor. Instead, Powell argued that the core principle emerging from the child labor tax case was this: that a nominal tax is in fact a regulatory penalty where it imposes an exaction that is triggered by departure from a detailed and specified course of conduct, and that exaction is sufficiently onerous to induce those engaged in the targeted conduct generally to alter their behavior. Powell credited Taft with fully recognizing that the distinction between a tax and a penalty was a matter of degree. But notwithstanding the difficulty of the inquiry, Powell thought that it was necessary if the federal system were to be preserved. Powell fully agreed with Taft that the decision upholding the tax would have led down a slippery slope to plenary congressional authority. The court's decision, Powell concluded, was essential to safeguarding the federal system from being warped beyond all recognition. Powell thus read the child labor tax case as establishing the proposition that the values of federalism could be preserved in taxing power jurisprudence only through the application of a standard rather than through enforcement of a rule. The healthcare decision provides an opportunity to reflect on that view. The dissenting justices maintained that the shared responsibility payment was a penalty rather than a tax because it imposed an exaction as punishment for an unlawful act. Accepting this definition of the distinction between a tax and a penalty made the issue turn on whether the ACA in fact made the failure to maintain minimum health coverage illegal. Because the dissenters believed that the ACA clearly did so, their formulation of the tax penalty distinction would have been sufficient to preserve their federalism values had Chief Justice Roberts agreed with their interpretation of the statute. But note that this is so only because of the way in which the statute was drafted. Suppose that Congress had denominated the penalty a tax throughout the statute and had made it clear that failure to purchase insurance was not itself illegal. The regulatory effect of the provision would have been identical, but because of its formulation as a tax on conduct in which individuals were legally free to engage or not to engage, the imposition would have been clearly constitutional. Thus, the dissenters' rule-like test was sufficient to preserve their values of federalism only on the facts of this particular case. But such unfavorable facts could easily be avoided through careful drafting, and the sort of standard that was championed by Taft and by Powell is far better suited to preventing Congress from exercising extensive regulatory authority through its taxing power. Now, such a standard, of course, has the usual disadvantages of standards: greater uncertainty of application, less constrained judicial discretion than one associates with rules, and justices who generally favor rules over standards for these reasons may be disinclined to adopt and reinvigorate such a standard. But as Powell argued long ago, that may be the cost of preserving the values of federalism and taxing power jurisprudence. Consider now the application of the child labor tax cases standard to the ACA. Take first the question of the burden of the exaction. Chief Justice Roberts did not regard the ACA's shared responsibility payment as imposing a heavy burden on the taxpayer. He observed that in 2016, for example, individuals making $35,000 per year were expected to owe the IRS about $60 for any month in which they did not have health insurance, while those with an annual income of $100,000 were likely to owe around $200 for any such month. By contrast, the price of qualifying individual insurance was projected to be around $400 a month. Indeed, it was estimated by the Congressional Budget Office that 3.9 million people each year would choose to pay the IRS rather than buy insurance. Well, I've already outlined the reasons for thinking that the Chief Justice may have overestimated the prohibitory character of the child labor tax. But he may also have been underestimating the extent to which the shared responsibility payment might be expected to induce taxpayers to purchase qualifying insurance. This is easiest to see for those who would pay the maximum assessment, which is equivalent to the national average premium amount of qualifying insurance, estimated by one expert to be approximately $15,000 for a family policy in 2016. In the case of employing child labor or manufacturing colored oleomargarine, for example, a law-abiding rational taxpayer weighs the benefits from engaging in the enterprise against the tax costs of doing so. And the fact that these taxes yielded revenue, in some cases significant revenue, suggests that in these instances, some individuals found it to be a reasonable financial decision to pay the tax rather than to desist from the conduct of tax. In the case of the individual paying the maximum assessment, however, it's difficult to see how it would be rational to pay the tax. He could pay $15,000 to an insurance company and in exchange receive minimum essential coverage, or he could make the payment to the government and receive nothing in return. Thus, it does not appear probable that a law-abiding rational actor would choose to pay the maximum assessment rather than securing minimum essential coverage. Of course, not everyone subject to the tax would pay the maximum assessment. Others would pay some lesser amount, equivalent to approximately 2.5% of their income. But even among this group, there will be some significant number of people for whom refusing to purchase insurance and paying the tax will not be the rational course of action. To see this, consider the projections of an Urban Institute study funded by the Robert Wood Johnson Foundation and published in March of 2012. That study estimated that 18.2 million Americans will be required to newly purchase coverage or face a penalty. Of those 18.2 million, 10.9 million people will be eligible to receive subsidies toward private insurance premiums in the newly established health insurance exchanges, but they'll have to make partial contributions toward their coverage from their own funds. And, the study concluded, about 7.3 million people are not offered any financial assistance under the ACA and will be subject to penalties if they do not obtain coverage. Well, let us assume that the CBO's projection that 3.9 million people will pay the tax rather than acquire insurance is accurate. If we also assume that the Urban Institute study's projections are accurate, then up to 14.3 million people, that is 76% of the 18.2 million potentially subject to the assessment, may be induced either by the tax alone or by the tax in combination with subsidies of various amounts to acquire insurance that they would not otherwise purchase. Moreover, CBO estimates that 1.4 million people whose incomes place them above the eligibility threshold for the subsidies will pay the tax. This suggests that up to 5.9 million people, that is 81% of the 7.3 million people in this category, may acquire minimum essential coverage rather than pay the tax. Of course, both of these percentages may be somewhat lower, as some unknown number of people may seek to avoid both obtaining insurance and paying the tax. But these numbers suggest the possibility that a substantial percentage of potential payers of the tax will be induced by the assessment to acquire minimum essential coverage. What Chief Justice Roberts might have made of these figures had they been presented by the litigants, we do not know, but if these figures are even remotely accurate, it seems far from obvious that the ACA does not impose, to use Powell's formulation, a tax sufficiently onerous to induce them generally to alter the conduct of their business. Now consider the second component of the test. Chief Justice Roberts characterized the shared responsibility payment as one that makes going without insurance just another thing the government taxes, like buying gasoline or earning income. This formulation makes the tax sound rather simple, like a tax on coloring oleomargarine, or taking bets, or selling opium. And the court has consistently upheld such simple taxes, even where the exaction was onerous. It is only where the exaction was coupled with a detailed and specified course of conduct, as in the child labor tax case, that the court has held the exaction to be a penalty rather than a true tax. The question, therefore, is whether the exaction imposed by the ACA is contingent on departure from a detailed and specified course of conduct. It is certainly possible to see it that way. Here's how I think the argument might go. After 2013, the ACA will require that all applicable individuals who do not maintain minimum essential coverage for themselves and their dependents pay the assessment imposed by the Act. If one does not have insurance or from some other source, one must secure minimum essential coverage through a purchase in the individual market. Individuals satisfying the mandate through acquisition in the individual market may do so either through the exchanges that are contemplated by the Act or by purchasing directly from issuers. The individual market is in turn extensively regulated in a detailed and specified manner by the Act. Companies selling health insurance in that market or on the exchanges must offer policies covering no fewer than 10 specified categories of items and services, each of which is to be elaborated by regulations promulgated by the Secretary of Health and Human Services. After 2013, it will not be legally possible to purchase a policy of insurance not meeting these requirements, and if one fails to purchase such a qualifying policy, even if one somehow manages to purchase a non-qualifying policy, one will become liable for the Act's shared responsibility payment. The Act thus may appear to tax only the failure to buy health insurance, but it structures the health insurance market in such a detailed and specified way that the failure to acquire minimum essential coverage can be viewed as a departure from a detailed and specified course of conduct. Well, if the understandings of Powell and his contemporaries in Congress and in the child labor reform community were correct then, there is an argument to be made that the shared responsibility payment of the ACA would not have been a tax within the meaning of the child labor tax case. If that conclusion is correct, then the ACA's mandate would not have been a tax even had the statute denominated it as a tax rather than a penalty. And even if Congress had expressly invoked its taxing power and professed an objective to raise revenue. The payment would be treated as a penalty rather than a tax because it imposed a sufficiently onerous exaction on a departure from a highly detailed and specified course of conduct. If that understanding is correct, then the Roberts courts may just have tacitly overruled the child labor tax case and its progeny. There is, however, another alternative to consider. It may be that Powell and his many contemporaries misread the child labor tax decision, and that a revised measure eliminating one or more of the distinguishing features identified by Chief Justice Roberts would have been upheld by the Taft Court in the 1920s. If this is so, then that generation of child labor reformers made a very costly strategic error. For the overwhelming support that the amendment enjoyed in both houses of Congress and from a variety of political and social leaders and organizations had left child labor reformers overly confident about the prospects for ratification. The amendment quickly encountered determined opposition from a variety of powerful and well-organized groups, and by the end of 1925, a year after it had been submitted for ratification, only 4 states had ratified the amendment, while 19 had rejected it. By 1932, the number of ratifications would grow to only 6 of the necessary 36, while the list of rejections would grow to 38. Beginning in 1933, we see renewed interest in the proposed amendment, and by early 1937, a number of states had changed their minds, and a total of 28 had ratified. But defeats in New York and Rhode Island later that year, along with the passage of the Fair Labor Standards Act of 1938, took the steam out of the movement. That act, which prohibited interstate shipment of goods produced by firms employing children, was regarded by many child labor reformers as offering at best half a loaf. Because the statute reached only firms producing for an interstate market, it covered only about 6% of the 850,000 children then gainfully employed in the United States, and only about a quarter of those who were working in non-agricultural occupations. The act did not cover children working in commercial agriculture, in stores or offices, in hotels or restaurants or service stations, delivering messages or packages, or selling newspapers or other items on the street. Indeed, under the understanding of the Commerce Clause that prevailed at the time, workers engaged in such local occupations could not have been reached by a statute exercising the commerce power of Congress. But because no such connection of the child's work to interstate commerce would have been necessary had the statute been formulated as an exercise of the taxing power, a measure based on the taxing power might have reached and thereby reduced or eliminated child labor that was beyond the scope of the Fair Labor Standards Act. But child labor reformers did not revisit that possibility, and instead persisted in their pursuit of the 8 remaining necessary ratifications. In this pursuit, they were to be disappointed. No additional states ever purported to ratify the amendment. Subsequent decisions expanding the scope of the commerce power would make it possible to regulate the employment of children in an increasing number of these occupations. But Chief Justice Roberts' analysis suggests the possibility that for at least 2 decades, leaders of the reform movement for federal child labor reform overlooked a constitutionally viable taxing power alternative that could have significantly reduced the employment of children in the United States. If that is so, then that unfortunate generation of social activists squandered precious time and resources in fruitless pursuit of a constitutional amendment authorizing Congress to regulate the labor of children, when a much easier and more expeditious solution lay right before their eyes. Well, the health care decision clearly resuscitated the progressive era asymmetry between the respective scopes of the commerce and taxing powers. Yet the decision leaves murky the future contours of a taxing power jurisprudence that is likely to become increasingly important. Chief Justice Roberts' opinion offers assurances that Congress's ability to use its taxing power to influence conduct is not without limits. But beyond the restrictions imposed by the Bill of Rights, it's not clear exactly what those limits might be. Because the Chief Justice concluded that the ACA's shared responsibility payment passes muster as a tax under our narrowest interpretations of the taxing power, he deemed it unnecessary to decide the precise point at which an exaction becomes so punitive that the taxing power does not authorize it. I've tried here to articulate reasons to question the contention that the shared responsibility payment actually does pass muster under the court's narrowest interpretations of the taxing power, even when given the benefit of a saving construction. Whether the Chief Justice would have seen the matter differently had such reason been presented to the court is a matter about which we can only speculate. But it does appear likely that one of 2 things is true. their assessment of that decision at the cost of the lost generation of federal child labor reform. Thank you.
Many of you have classes to teach or to attend, but we do have some time for questions. If you do need to leave, please excuse yourself. I ask one thing of everyone. We don't want the dining hall staff to have to clean up after us, so if you can bring your rubbish and your trays back downstairs. The constitutional phase minor is offered. First question from undergraduate students. So if there's any undergraduates that have a question, I'll let you begin, and if not, we'll open it up.
Professor, not to make you give a whole additional lecture, but I wonder if you have any thoughts about the 4 dissenters plus the Chief's Commerce Clause take. This whole argument that the Chief Justice gave us about this being a permissible tax happened only because apparently he concluded that the Commerce Clause wouldn't authorize this. And I wonder how plausible you think that conclusion is.
The question invites me to offer my opinion about the Commerce Clause portion of the court's opinion in the Affordable Care Act case, under which you recall that the majority, that is Chief Justice Robertson and the 4 justices who dissented from the holding of the taxing power issue, agreed that Congress does not have power under the Commerce Clause to impose the individual mandate. I'm not a fancy constitutional lawyer. I'm just a nerdy constitutional historian, and I don't have any well-developed or respectful normative views on the Constitution. But I will say this: based upon the precedence, the expansion issue was decided the way it was, and by a vote of 7-2. Now, after oral argument, I mean, a lot of us thought maybe this Commerce Clause question is a little closer than we thought it was based upon the precedents. But before oral argument, I regarded all 3 of those contentions as surprising. So I think that it's arguable that the court has opened up new frontiers in 3 domains of constitutional law: in the Commerce Clause domain, in the taxing power domain, and in the spending power domain.
I want to out-nerd you. I retain only maybe 4 or 5 words of all you said. There's nothing I insult to it. At one point, you're quoting Chief Justice Taft is talking about the arc of our covenant. And that strikes me, as a religious person, that's awful. How could anybody think that we, or the Constitution, constitutes anything like the Old or New Testament covenant between religious people and God? And so the question is, did you get that right? Or, and then secondly, am I wrong in thinking that's sort of a bit of a hyperbole?
So the question is, did Chief Justice Taft actually say what he said he said?
Is that what you think of it?
And isn't that deeply offensive?
Yeah.
So yes, he did say what I said he said. I did quote him correctly. I think that you would be fair in saying that he made a categorical mistake there, right? That you might characterize it as our covenant, right? That is, it's our social compact. It's our agreement with one another.
It's the arc part.
Yeah, it's the art part that is where the category mistake lies.
This may be an unfair question because David at this point, but one is arguing that in these 3 areas we have seen the Supreme Court make a major constitutional shift. But how much of that is driven by the extraordinary nature of the law at issue and the political consequences going one way or the other, especially with this piece of legislation. I'm reminded of the question about Wood versus Gore, whether the actual holdings in that case are really applicable precedents, or was it more driven by the arguably unique context of that case, and so there's a reluctance of the lower courts, maybe on the Supreme Court, to rely on the reasoning in that case for another context. If you have any thoughts on what that means here.
So tell me if I'm formulating this correctly. The basic question is, to what extent do the doctrinal moves that the court makes in the Affordable Care Act, these have legs? It's hard to say. One of the reasons why on the Commerce Clause side it was thought to present a case of first impression is that you don't have much precedent for Congress mandating activity, that is, mandating someone to engage in commercial activity for the purpose of regulating. That was kind of a new phenomenon. And I don't know how often we could have expected Congress to engage in that activity in the future. Certainly there were a bunch of hypotheticals that were spun out in the run-up to the decision. We'd be forced to buy Shed and Volt and all the rest, right? There was the broccoli example. We'd be forced to buy broccoli. That, it seems to be foreclosed. I think it's pretty clear if Congress doesn't have the power in the Commerce Clause to force us to buy health insurance, it doesn't have the power to force us to buy broccoli. At least I think that's likely. With respect to the taxing power, though, it's really hard to know. I mean, this is the point that I tried to make at the end. He just says, there's some point at which we're going to blow the whistle and say no, but we're not going to give you any sense of where that point lies, and we haven't really formulated a workable test, because the test that they use, whether the underlying conduct triggering the tax is unlawful, is not the test that has applied in all these contexts in the past, right? And if you think about it, there's a reason for that, right? The reason why the statute didn't make the employment of child labor unlawful is that Congress didn't have the power to make it unlawful, right? That's why they imposed a tax for engaging in the conduct, right? And the same was true with respect to the other cases involving regulation of futures markets and regulations of the coal industry. Congress didn't have the power to make it unlawful, right? That's why they didn't make it unlawful, but nevertheless the taxation of the activity constituted the penalty, right? And if it actually, I'm still trying to work my way through this, but if you think about the structure of the court's opinion, right? Initially, they say that Congress doesn't have the power under the Commerce Clause to command us to buy insurance, which means that Congress doesn't have the power to make the failure to purchase insurance unlawful, right? At that point, it seems to me that you're right in the wheelhouse of the child labor tax case, right? Because you said you can't make this unlawful, or it can't be unlawful not to purchase insurance, right? Therefore, it's a tax on an activity in which you're free not to engage. Right? So I think that the court is going to have to clarify its jurisprudence. It seems to me that the excise tax precedents were remote. People don't even teach them in law school anymore. I think that's going to change, right? They weren't particularly well briefed and argued before the court in a robust fashion because everybody thought the case was going to turn on the Commerce power. And as a consequence, I think they've got some work to do to develop and clarify the tax and power jurisprudence. That answers your question.
Mayor, I have a lot of questions for you. You make the point in the Chief Justice's opinion, the case, relied in some way, it was implied as mistakenly on the child labor tax cases, a statement that the tax was inhibitory, implied that it doesn't account for the fact that it continued in a raised revenue as evidence for the prosecution. It wasn't the fact. But do you think precedents, old precedents, what does the current judge or justice or scholar do dealing with the system of proper precedent to look behind what the court actually did say, how it did actually say? And your claim is that you made a mistake, which is wrong about that, it's not a fact. Does that change the doctrine of the court's ways?
Well, I don't know whether it seems to be one or two things is possible. Either Taft was wrong, or he was using the term prohibitory, in a way, right, that is misleading, right? But that's not. He didn't mean that it completely eliminated child labor.
In effect.
Right. I'm sorry.
Prohibitory in effect.
Well, but this is what I'm saying, is that it had a tendency to diminish child labor substantially, but it did not in fact prohibit it. I don't know exactly what he meant by prohibitory, right? But I think it's the duty of the litigants, right, to clarify that for the court and to say, you can understand this as Chief Justice Taft making a mistake. You can also understand he was using the word in a particular way. And this is what the meaning of the word was as he used it in that context, right? And that's the meaning that you should take from that case when you're deciding this one. But the litigants didn't do that in this instance. Right? The taxing power case was briefed by a couple of amici on the pro-ACA side, but there were no amici doing the taxing power issue on the anti-ACA side. So they were left with the parties' briefs, and the parties really relied pretty heavily on the statutory construction issue. Right? They thought that was going to be determined. It's called penalty. It's a penalty. It didn't work.
Wait a minute.
Just a historical question about the proponents of child labor prohibition. And I'm just trying to get some clarification. You made it sound like they came to agree with the Chief Justice's point of view. Did they agree so much, or did they just say, well, it's time to fold our tents and try another?
Yes.
All people, when we want something out of the federal government, we try any avenue that's available.
Right. Yeah, it's more the latter. It's they didn't agree that the Chief Justice had necessarily gotten some of them did, right? Some people like Powell, he had initially suggested the possibility of a taxing power solution, right? But he came to reflect on it, and after 3 years, he thought, after all, Taft was right? But there were others who just thought, look, the Supreme Court's erected a roadblock here. There's no way around it. We got to try something else.
Two more questions.
Sure. So, if you imagine a world where the court does revisit the scope of the taxing power and returns to an interpretation that would be in line with the child labor tax case, just to kind of tease out a little bit more what that case actually meant. If you then imagine a battle by environmental reformers actually put into place, say, pollution taxes, where you have a detailed regime of what emissions you can have, and a tax on those emissions. Environmental reformers would do better to justify that under the Commerce power than under the tax power. Would that be a fair statement?
I think that's right, yeah.
Even though it double tax.
I'm sorry?
Even though the legislation perhaps called it a tax.
Right. What the lesson of child labor tax case and its progeny is it doesn't matter what you call it, right? You can call it a tax an infinite number of times, if that's possible. It's still a penalty that has the following characteristics. If it imposes a detailed and specified course of conduct and an exaction for departure from that conduct that's sufficiently onerous to induce people to generally alter their behavior. Right? So what you're describing, it seems to me, would be a penalty within the meaning of the child labor tax case, and environmental activists would be better served by trying to justify it under the Commerce power. Now, of course, this was an excise tax, right? If you house this in the income tax, there are certain advantages that, and I won't take you into the weeds here, but certain advantages that spring from the court's justiciability doctrine. That is, if you characterize it as a credit or a deduction rather than an exaction, you have certain procedural advantages. And that's the way a lot of regulatory activity under our income tax code works, right? It's performing regulatory functions. If it were an excise, if it were construed as an excise, it might be considered unconstitutional within the meaning of child labor tax. But because it's put in a particular form in the income tax, it's basically moved from challenge.
So if the name is less important, the last question would be what about how it is carried out by the executive and how the executive claims he's carrying out? So if he is going to say, I'm not collecting a tax, I am collecting a penalty, is there room for a suit to say that effectively the executive branch is not complying with the Supreme Court's decision because it's continuing to collect a penalty instead of a tax, taking Congress out of the picture and moving to the executive?
Yeah, I think one of the lessons of the decision is that it really doesn't matter what political actors call it, right? What was much quoted in the run-up in some of the briefs that were presented was the fact that President Obama had said in an interview with some media organization, I'm not sure, that this did not impose a tax, right? That it wasn't a tax, and now the government was coming back and saying that it was a tax. And what the court effectively said is it doesn't matter what President Obama called it in that interview. This is an independent issue for constitutional analysis by us.
One final announcement before we thank Dr. Cushman again. On Friday, this coming Friday, this time in the North Dining Hall at noon, the Constitutional Studies program is having a panel on Notre Dame's lawsuit against the Obama administration. The title of the panel is Why is Notre Dame Suing the Obama administration to protect religious liberty, and should it be doing so? And we have an all-star panel, Mark Lowell from the History Department, Jerry Bradley from the Law School, Ann Estelle from Theology, and Mary D'Angelo from Theology. So please come join us on Friday, noon in the North Dining Hall, and please join me in thanking Dr. Barry.